Hi, thanks everyone for joining us. This is Robert Weissman. I'm president of Public Citizen. I'm joined today by Deepak Gupta, who's an attorney with our litigation group and is representing consumers in the case AT&T Mobility v. Concepcion. I'm just going to give you a couple minutes of overview, and then Deepak will talk about the case, and then we'll be available for any questions you have. The case coming up, which will be argued November 9th before the court, is going to be one of the landmark cases in consumer and employee access to justice. What is at stake in the court's decision will be whether consumers can effectively band together to bring class action cases to advance and defend consumer interests, or whether employees can do that, particularly in cases that involve relatively small amount, most important in cases involving relatively small amounts of damages to individual consumers or individual employees. The legal issue that's at stake, which Deepak will talk about, is whether contract provisions from large corporations can override consumer rights to bring class actions, and particularly whether a long-standing federal law preempts the ability of states to establish a right to bring consumer and employee class actions irrespective of some contractual terms. In this case, the Concepcions had purchased a mobile phone service from AT&T and thought they were getting a free service, but found out they were hit with a a little bit above $30 charge. They wanted to bring a claim and say that they were victims of a deception by AT&T. It's obviously not worth it to them on their own, just as a monetary issue, to bring a $30 claim. But if they're able to band together with many other affected consumers, then the case does become worth it. And it's important, not just for the $30 out of the pocket of the Concepcions, but because of the aggregate effect on all consumers and the improper benefit that AT&T would receive if there's no check on their misbehavior. So class actions are very important in remedying these kinds of abuses affecting consumers. They're also very important in remedying comparable abuses that may affect employees. For example, if employees are underpaid as against promised wages, or if they're not paid minimum wage, those kinds of cases typically run as class actions and often not worth doing if they only involve one or a couple employees at a time. So there's this huge impact on the ability of consumers and employees to get remedies for harms perpetrated against them. And there's also a social importance about whether corporations can be constrained. If they basically have a free hand to undertake these kind of abuses, so long as they don't get caught by government enforcement agencies, they're going to go ahead and do it. But the existence of class action litigation, prospect of class action litigation, deters them from a lot of misbehavior that would otherwise take place. So there's really a great deal at stake in this case that is now going before the court November 9th. If you look at all of the parties who've lined up on the two sides, you'll see that business interests agree this is a very important issue for them. They are trying to escape the accountability that the court system provides in these important cases. And you can see that large numbers of consumer organizations and employee rights organizations have lined up to take the side of consumers and employees and make sure that we maintain the right to join together in class actions without having those rights suppressed by the simple fact of a corporation writing a form contract that says you're not going to have a class action right. So with that, let me turn it over to Deepak, who can talk a bit more about the case in general, but also get much more into the specific legal issues involved.
Yeah, I think that was a good summary of what the practical implications are. And just to make this more concrete, so the question, first of all, the legal question before the court is whether companies can ban class actions in the fine print of contracts with their customers and employees. The question is whether or not those kinds of class action bans can be enforced. And what the lower courts have held in a series of decisions by state Supreme Courts and federal appellate courts is that those class action bans are unconscionable, which is just a fancy legal word for unfair. And under ordinary principles of state contract law, the courts don't enforce those provisions. They hold that they're one-sided, the companies are effectively inserting a provision that favors them, and most people don't read standard form contracts or have the ability to negotiate them. So if you're taking a job as a dishwasher at a fast food restaurant, for example, or going to work for a big box retailer, you don't have the opportunity to negotiate the terms of those contracts. They're take it or leave it contracts that are written by the lawyers for the corporation. And so if the terms are one-sided and unfair and there's no real opportunity to negotiate them, under ordinary state law principles of contract, those provisions won't be enforced. The question is whether a provision that's otherwise unenforceable under state law, if it's embedded in a mandatory arbitration clause, is suddenly enforceable. So I want to explain a little bit about what mandatory arbitration is and what the federal law on that is, and why this is a question before the Supreme Court. To give you a little background, there's a federal law called the Federal Arbitration Act. It was passed in the 1920s, and it was originally intended to facilitate business relationships where two businesses agreed to settle their disputes outside of court. They would agree to appoint a private arbitrator, and that person would settle the disputes. But over the years, the Supreme Court has interpreted that federal arbitration law to allow consumer claims, civil rights claims, to also be sent to mandatory arbitration. And so these provisions have become ubiquitous. They're in, if you get a credit card, if you get a cell phone, if you admit a family member to a nursing home, you take a job with many big employers, you're probably signing a mandatory binding arbitration clause. Now, it's settled already that those clauses are generally going to be enforced because of a series of Supreme Court decisions. The question in AT&T versus Concepcion is whether companies can also use those mandatory arbitration clauses to ban class actions. So in other words, you're giving up not only your right to go to court, but your right to band together with other people who've been similarly harmed to redress a set of common grievances. And as Rob explained, if the damages are small, if you're talking about $30 overcharges on a cell phone bill, the reality is that no lawyer is going to bring that claim on an individual basis, and it's not really worth anyone's time to prosecute the claim, especially when it's expensive or difficult to detect the wrongdoing. So, for example, if a company is cheating its employees on the minimum wage, that could be happening across millions of employees, but in very small amounts. It'd be very expensive to detect those violations, and so a class action is really the only meaningful way to redress those wrongs. So the question before the Supreme Court is whether the court is going to essentially overturn all of these lower court decisions that have found these class action bans unconscionable under state contract law because the Federal Arbitration Act, which has a policy of favoring arbitration, trumps that state contract law. Now this would be a really radical decision by the Supreme Court because no state Supreme Court or federal court of appeals so far has held that the federal act trumps the state law. So it would completely upset the status quo, and it would really sort of close the last safety valve that's available to consumers and employees. It would effectively mean that mandatory arbitration functions as a get-out-of-jail-free card for companies that commit wrongdoing across millions of people. I think that's a fair summary of what the case is about, but I'm happy to answer any questions.
This is Jesse Kamens from BNA's Class Action Litigation Report.
Great, go ahead, Jesse.
I wanted to ask, am I correct that is this right that all state Supreme Courts and all circuit courts of appeal have come out that the FAA does not preempt the state unconscionability laws?
Yeah, Jesse, that's correct. I mean, the only one exception was that the Third Circuit, which covers New Jersey, Pennsylvania, and Delaware, originally had a decision that suggested that there might be preemption, but that court then issued another decision that overruled that prior decision. So it's clear now that all state Supreme Courts and all federal court of appeals hold that there's no preemption. So The status quo is that AT&T's argument fails in every court across the country. So it really would be a radical departure for the Supreme Court to agree with AT&T's argument.
This is Jesse Kamens again. But there is a split among states as to whether or not class action waivers are enforceable. Is that correct? Is that the distinction?
Yeah, that's right. And even there, it's hard to say that it's a clear split because deciding whether a contract is unfair is really a fact-intensive inquiry. And so two class action bans may not be treated alike, but it could be because one of the contracts allows for the recovery of attorney's fees, for example. It also depends on the kind of case. If it's a case involving small value consumer or employee claims, the courts are more likely to strike down the ban. If it involves home mortgages, for example, and people could really bring those claims on their own and get a lawyer to do so, the courts are more likely to uphold the ban.
Hi, this is Pam McLean, a California lawyer in San Francisco. Can you talk a little bit more about the question, the fine point the court's going to be resolving between, I guess, the Stolt-Nielsen decision from last year and earlier? What exactly is it that they're going to be looking at?
Sure. The question is whether the Federal Arbitration Act preempts state law. And the Federal Arbitration Act says arbitration agreements are enforceable except on general principles, except on the basis of general principles of state contract law. And so the question here is whether or not the state courts are applying general principles of contract law or whether they're discriminating against arbitration. In effect, the Supreme Court has created a kind of equal protection clause for arbitration. And the other side argues that the California courts and other states are discriminating against arbitration. And our response is that the courts are actually treating class action bans the same, whether or not they're in arbitration agreements or not. So there are some examples of cases where companies have included class action bans in their contracts, but there's no arbitration agreement, and the courts strike those down as well. And so our argument is that that shows that there's no actual discrimination against arbitration. You mentioned the Stolt-Nielsen case from last term. That was a case in which the court split 5-4 and held that when an arbitration agreement is silent on the question of class arbitration and the arbitrators allow a class action in arbitration based not on contract principles but based on their own views of public policy, that the arbitrators have exceeded their authority. And it's true that in some of the language in that decision, which was by Justice Alito, the court expressed some skepticism about the viability of conducting class actions within arbitration.
Well, maybe we can say as a final note that, as is common with litigation before the Supreme Court, the actual issue that's being debated is fairly technical, a little bit arcane, and relies on overlapping legal principles that aren't intuitively obvious to regular people. But at the end of the day, what's at stake here is pretty simple and very far-reaching, great import for consumers and employees and the enforcement of civil rights rules. And that's just simply whether through contract corporations can deny consumers and employees basic rights by saying that they are not able to bring class action cases. And if they're not able to bring those class action cases, they're just not going to be able to enforce their rights. It's going to give a free hand to corporations to engage in a variety of either deceptive or misleading practices, small charges, small fees, small rip-offs, small defects, taking a little bit out of an employee's paycheck here and there in ways that aren't immediately obvious. It's going to be very hard for people who are victims of those kinds of abuses to get any kind of redress if they don't have class action rights, and their ability to bring class action litigation is what is at stake in this case. So it is, again, involving some arcane issues, but really with profound stakes for the ability of consumers to be protected, for employees to be protected, and for the market economy to work with any sense of fairness.
And you know, one way of looking at this is just I agree with Rob that the legal issues can seem quite technical, but think about it this way. If businesses were to try to go to Congress or the state legislatures and get them to ban all class actions, they wouldn't be able to do that. They've tried that and it hasn't worked. What they're attempting to do in this case is to achieve the same thing through the fiction of fine print contracts and by resurrecting, you know, these principles from a 1925 statute where Congress couldn't have possibly intended that. It's really a radical step, and it's in keeping with some of the moves that the Supreme Court has made in this area in mandatory arbitration cases over the past several years. The class action device is really central to how we secure rights on behalf of groups in this society. Brown versus Board of Education was a class action. So if we're going to take the step of banning class actions, there ought to be a political debate about that. It shouldn't be done based on these very arcane legal technicalities.